And so he wasn't the one that would.
I apologize, Your Honor.
Yeah.
That's okay. That's fine.
So,
Is that baseball?
Sure.
Is that baseball?
I don't know what factual basis.
That's okay. I'm a baseball fan. So.
I don't know what.
Mr. Pepperman.
Your Honor. First, I just have to comment that Mr. Rasmussen was pointing to the screen and saying that the issue was whether these instructions on the screen are good or not. But those instructions were for the oxidation kit that was discontinued in 2017. They were not in use. That's not the instructions.
I understand. I do.
So I don't know if he's trying to confuse the issues here or create some sort of problem, but this oxidation kit and those instructions are totally irrelevant. They were not in use. That kit was discontinued in 2017 because it causes cancer. They found an old one in the real water facility that had a bunch of other junk in it that was being stored, but that has nothing to do with this. Getting to the motion at hand, respectfully, this is not a good faith motion. First and foremost, this preservation obligation, this evidence, this was not our evidence. This was Real Water's evidence. Real Water was in possession of these meters. All we did was come into the case and say, hey, we need to look around and see what we need to do to preserve what is in the possession of the defendants in this case. One of the things that we did was Real Water was in breach of the lease of its facility, and we were concerned with that. So we stepped in and took over the payment obligations so we wouldn't lose the facility and the landlord dump all the potential evidence that was in the facility. But that wasn't us taking responsibility of any of the evidence. It was just saying, hey, let's pay the rent so this doesn't get thrown out just in case we need any of this stuff later. This argument that by us taking steps at great expense to preserve the availability of evidence, we don't know what was there. We weren't saying we need to, keep the meters in any type of liquid solution. I mean, we weren't operating these meters. We weren't in possession of them. In reality, pursuant to a stipulation and order, we facilitated moving the meters to a joint storage facility. The meters were in the water present pursuant to a stipulation and order, and we just transported them to the joint storage facility, which, contrary to Mr. Rasmussen's suggestion, and we didn't know if it needed to be air conditioned, but we thought, there's water. We didn't know what the testing in the water was going to be. We didn't know if...
When did the transfer occur from Mr. Mueller's custody and control to the joint facility?
I believe in April of 2021. And I can confirm the date. We have the custodian, the chain of custody affidavit from Mr. Mueller, his staff. We made sure that they mailed.
How long had it been in Mr. Mueller's possession, and where did he have it stored at? I just want to make sure I'm clear.
So I can pull that up for you, Your Honor.
But, we're getting really sidetracked in this one respect, because I come back to the issue regarding how does this preclude the defense from defending the alleged products liability claim based upon inadequacy of warning, inadequacy of labeling, inadequacy of potential inference.
Well, it doesn't. That's the other point. It's not only they're trying to strike our complaint for not preserving evidence according to the way that they wanted to, even though we did it pursuant to a stipulation and order to just try to facilitate that this evidence was available. It was stored for more than 2 years. Milwaukee and Hanna have been in the case for more than 2 years. They never once said, hey, where are the meters stored? Are they in solution? Are they here? Are they there? Honestly, most of them were still new in the box that we preserved. You saw those pictures. Those are meters in the box. They don't come with solution. They're not in solution to begin with. We are ordering these meters now that were manufactured around the same time. They've been in existence for years, packaged in the box. There's no reason to believe why these meters could not be tested or function. And even if they couldn't, I think Your Honor gets right to gets right to the core of the issue. It's not relevant. Having the exact meters and being able to test the exact meters that were in use at Real Water it doesn't change anything because the inadequate warnings, instruction, and labeling are the same. The issues don't change with respect to what's relevant to our claims. And I go back to the claims in the motion to strike the plaintiff's complaint are just disingenuous and factually inaccurate. No one, you didn't hear Mr. Rasmussen say once that they ever tried to inspect or test these meters prior to June of 2023, after their expert completed his testing using different meters. They never sought to even look at them.
What's implicit in not testing the meters? Well, there's two things I can say. Number one, we know meters were utilized for the purposes of potentially recreating or attempt to recreate the conditions that were present at Real Water on some level. And what I mean by that is there was some testing going on vis-a-vis a solution. I made my decision based upon the fact that it wasn't the same solution that was created. I guess that's probably the best way to say it. But just as important, you pointed out, because I want to make sure I use the appropriate term. I think the term is conditioning, right?
Conditioning.
Right, because I don't want to open a can of worms. I just don't. I want to stay away from that.
Everyone uses the terms interchangeably except Mr. Rasmussen.
Yeah, but my point is this. If it was critical to have the exact meters at issue tested, why weren't they tested during the appropriate time, right? And apparently the expert didn't think it was that important because he would have tested them, right? And I don't know if this is, and maybe I'm wrong, but I come back to this. This isn't a design defect case. This isn't a manufacturing defect case. This is a warning case based upon strict products liability, warning to the... I get that. And so I'm trying to find out in a general sense, because this is what's often overlooked. And I think, although it's a very short case, Bass Davis is really a great case on this issue. And the reason why I say that is this, and that was a case, remember, regarding the video, right? The video camera. And it was just a simple slip and fall at a 7-Eleven. And there was no question that there was video taken. And the issue at hand was whether there was a sign placed in the appropriate position that would have warned the plaintiff of the wet floor. It's really that simple. Plaintiff said there wasn't a sign. Defense said, yes, there was a sign. And the rest is history as far as the case is concerned. But that's clearly relevant in a premise liability case, right? And we can all agree. But I'm trying to really focus on if this was such an important piece of evidence that would mandate striking an answer, and it was so relevant, there was testing done. And it seems like to me the first impulse would be this of any expert. If he thought that was so important, he would have tested, said, look, before we conduct this testing, can you produce the original or the meters that were in place at the time that's in storage? Produce that, because I want to use that as the basis for my testing to see how they perform. And that didn't happen.
It did not happen. It was never tested. They never asked to inspect the meters before the testing. They never asked to take pictures. They never asked to look at pictures. It had nothing to do with it. He did his testing, and it was fine. It wasn't until after the fact, after his testing, after his initial report, after his rebuttal report, after his deposition, when none of this was important, until I start asking him, well, why didn't you compare the test meters to the meters we have at Real Water to ensure they're the same for your test results? Only then did they go out there and only then did the experts start looking at pictures and then say, oh, well, I couldn't have tested it. It was all after the fact to try to clean up the fact that they didn't do it before because they didn't need to, they didn't want to, they didn't try. And I do want to add one more thing to that because there's another level of it. Chris, can you pull up the Salvaggio message on reactivating? So in the manual, it states, yeah. So the argument too was, well, we couldn't test them because they're dried out, and our expert looked at a picture and says they're dried out. Carl Salvaggio says if it dries, it dies. That's Mr. Rasmussen's representations on these issues. Number one, none of that was known or suggested until after the fact because they never looked at it before the testing. They never bothered to look at it at any time during discovery to see whether these meters were dried out or could have been tested. So they're just saying that, number one. Number two, this is what Carl Salvaggio says in a customer in response to a customer question on this issue. Says he doesn't say it dries, it dies. He doesn't say, oh, sorry, your meter can't be used because it's dried out.
And for the record, when you say Carl Salvaggio, you're referring to?
He's the president of Milwaukee Instruments and the vice president of Hanna Instruments.
Okay.
So he's an executive in both companies. And so in this capacity, he's answering questions on behalf of Milwaukee to customers who have purchased the Milwaukee 500 meter and are asking questions. And he says, if you look at the fourth one down, it starts with, in the manual it states, when the electrode is new, always remove the electrode protective cap before taking any measurement. If the electrode has been left dry, soak the tip in storage solution for a few minutes to reactivate it. If you have more time, you can leave it overnight to then test in the morning. So what he's saying in response to a customer, he's not saying if it dries, it dies, like Mr. Rasmussen is saying. He's saying if it dries out, no problem, put it in some solution and you can reactivate it. So not only did they not think it's important enough not to test, never sought to test it, never sought to do anything until well after the fact, June of this year, June 23rd, long after the close of discovery, did Dr. Babcock even look at this. But even their premise of it, we couldn't have done it anyways, isn't true. They could have reactivated. They could have tested these things if they thought it was so important. They didn't do it, Judge, because it's not important. It's not relevant. And now, after sitting on their hands for 2 years, never saying a word about it, after not trying to test it, not inspecting it, not looking at it, never raising a concern about the storage conditions, now they're coming into court the week before we start trial and saying, strike their answer because we destroyed evidence that was really never in our custody or control. It was always in Real Water's custody and control, and it was Real Water's responsibility. So for all these motions, for all these reasons, the motion we respectfully ask is summarily denied.
Mr. Salvaggio said something different. Let me go to that first.
And let's go back.
So it's easy to cut and paste out things and say, well, this is what he said, and that's the way it is. Remember, Your Honor, if I get my math correctly, the plaintiffs have had custody and control of these meters since April of 2021. We got the Motley report in March of 2023. So it's not quite 2 years. I guess it's 1 year and 11 months later. Okay. So Mr. Motley, in section 7 of his report, we'll go there first, I guess. Mark, can you get to that section? This is what I'm going to have to rebut. This is my specific issues and opinions. Again, the primary issue of this report is, in my opinion, whether users of the MW pipe were provided with adequate warnings as to the dangers of improper oxidation and calibration. It's factory calibrated. So I'm looking at this and saying, okay, so what's he telling me? I have to worry about calibration for a factory calibrated machine. This is the plaintiff's report. Make sure that we understand. This is Michael Motley. This is what he's telling me. Adequate warnings have to avoid these dangers. My conclusion after examining the information available to me is that no sufficient or adequate warnings were provided to users. And some of the rationale is as follows. The user identifies no warnings whatsoever given inadequate information regarding oxidation and gives misleading information regarding calibration. Now, I've got misleading information regarding calibration. And he knows the difference between the two. He's named both. Oxidation and calibration. We did our test to see whether or not these things could be oxidized. We did that. That's what you said we can't use. Gives misleading information regarding calibration. Now I'm down the rabbit hole of, well, what is he talking about with regard to calibration? So
I kind of think, I mean, this is the first time I've seen it, but it appears to me it's pretty clear. This is what's not being highlighted. Again, the primary issue of this report is my opinion on whether users of the MW500 were provided with adequate warnings.
Okay, I don't disagree with you. So how do we know if they're adequate or not?
You have your expert review the warnings and make a determination.
And we have that report.
Okay, then that's a question of fact for the jury.
So then one of the things we can do is, okay, with regard to calibration, because we got hung up on this, calibration affects the accuracy of the meter.
Yeah, but I mean, at the end of the day, your defense to this case is to be really this simple. Ladies and gentlemen of the jury, the warnings in this case are adequate, and this is why. That's your.
I agree with you, Your Honor.
I mean, that's.
But we can also. I apologize.
No, you didn't. I'm listening. I'm just saying it's a warning case.
I agree that it is a warnings case. There are ways in which to defend a warnings case. Questions that the jury could ask is, were these probes accurate at all? In other words, if I come in and say, okay, well, let's see what real water did. Here are the probes that they actually had. Okay? Here's the ones they were using at their facility.
Well, I mean, I don't know for sure, and I'm speculating here. I think, and the reason why I'm speculating a little bit, because I don't think there's a claim for relief as it relates to product design and or product manufacture, right?
Let me go to the complaint.
Okay, right, there's nothing there. And so my point, and I think that's very, very important, it deals with warning and potential, I think in conditioning the safer way to go, you know.
I would like to just use conditioning, but the problem is, this is what his report says. What am you know what I'm saying? When your report says the word calibration, I've got to worry about it, don't I?
Well, no, I don't know if you do it. I think what you have to worry about is are the warnings or instructions to the end user adequate or not as far as warnings are concerned.
No, I can see that this might be
No, but I mean, I think it's important to make a record. And what you're doing is you're making an allegation for spoliation of evidence, right? This isn't like Bass Davis where the videotape was lost in transmission or in when it was sent to the insurance company, right? And it came up missing. This isn't the same issue. Your expert has opined on warnings and the adequacy of warnings, right? That's what's going to go to the jury. And the jury's going to make a determination based upon this report and the testimony, well, not the report, but the testimony and the basis for the opinion from the plaintiff's expert. And then conversely, they're going to listen to your expert. You can say, no, this warning's adequate and this is why. Am I missing something here?
No, Your Honor, I think the thing that I think we wanted to make sure that we could do is whether or not, if we showed that the probes were accurate, then the questions of oxidation and calibration. If I took the probe out, it was tested, showed that it could oxidize properly. We could show, look, here's the instructions, we're following exactly the way that was in the instructions and warnings that were given. We're mimicking those. Look, here we go. They did exactly what they're supposed to.
You know what would be product spoliation in this case would be if there was only one warning, one instruction, and I know it's not, but there was only one set of instructions as to product use in the possession of the plaintiff, and the plaintiff lost that one set, then potentially you have spoliation, right? Because it couldn't be recreated. But we have the warnings, we have the product inserts, right? We have the instructions or whatever the manual might be as to usage. We have that.
Okay.
And we have the plaintiff's expert. We have your expert, who I would anticipate is an expert in this area when it comes to product warnings. And I realize there's quite a few different types of individuals that can opine on that. But I know many times when it comes to certain issues, you might have psychologists, you might have human factors type that deal with warnings and all those things. There's it's a specific area, and I'm quite sure both sides have individuals that can opine on those issues. But see, and my point then I come back to is this: can't you defend the instructions given by your client as it relates to the adequacy of the warning?
Yes, Your Honor. If we can, you would indulge me for a minute just to show the second amendment complaint of the plaintiff so I can show you what has been pled against me. And I can show you that's a little bit different than just that simple thing that you just said.
Okay.
Is that okay, Your Honor?
Okay. And before we go there, and I understand complaints allege a lot of things, but do they have an expert on product design, or do they have an expert? Okay. Do we have an expert as it pertains to issues regarding problems in the manufacturing process?
No.
Okay.
They have an allegation with regard to those things, I believe. Can you just show me the second amendment complaint, causes of action 6 and 7? We'll just read them, and they want to say these are not have anything to do with that, but they're saying that it's a dangerous instrument.
Because of the warning, or lack thereof, I guess.
So long as it's limited to that, then I see your point. You have the complaint, second amendment complaint?
It's in motion on
Pleadings. John, do you have it real fast?
You don't want to take a break for a minute? We don't care.
Take that one. All right, the second amendment complaint is demand for jury trial. The date of this one, Your Honor, is March 9th, 2023. So here's the complaint as of, 4 months ago, 5 months ago?
Right.
Okay? We can go to, I don't know who's got it, cause of action 6 and 7.
Picture of it right there.
There we go. So you didn't warn. We're right. Okay. What did we not do? We didn't warn about in section 157 that the ORP cannot effectively read a negative ORP state unless the platinum tip is properly oxidized. This is what we've been talking about.
Right.
Okay. We try to do testing to do that. Okay. Number 2, the damage must be cleaned every 30 days. Okay. I think that's been abandoned, but we'll see. Number 3, that the MW must be calibrated every 30 days. It's factory calibrated. We'll show that again if we need to, but it doesn't apply here. Okay. Number 4, the meter must be replace every 12 to 14 months, especially when used for negative ORP readings. Okay. So this is about the other prominent warnings on the meter. Okay. Go to the, let's zoom out and go to the next cause of action. Seventh cause of action. Seventh cause of action. All right. Unreasonably dangerous against defendants in Milwaukee. Is a unreasonably dangerous product because consumers would not expect the following. Now, this is a reasonable expectation test. Would not give accurate readings when used for negative ORP. No, this is a little different, isn't it? This is not just warnings now. Those words don't appear here. This is an unreasonably dangerous product because consumers' expectation is this.
Well, that's part of, I guess, which case was it? Is going back to Harley-Davidson and the consumer expectation test, and they rejected the other test, something like that.
Rahal, Your Honor.
Yeah, something like that.
Number two, that it would not give accurate readings when used for negative ORP measurements unless it's rigorously cleaned every 30 days.
Right.
Just cleaning is certainly not our. I don't know how it's unreasonable to clean something, but that's part of the reason I think it's not being really used here. And I asked Mr. Motley directly, what are you doing with regard to cleaning? He says nothing. I have no opinions with regard to cleaning.
Well, I think he's focusing on the adequacy of, is that, who was the expert again? What was his name?
Which one? Babcock?
Plaintiff's expert.
Plaintiff's expert is Mr. Motley.
Okay.
Dr. Motley.
Yeah. But my point is this, he's there just focusing on the warning issues.
Well, one of the ways that we can do this, of course, is that now you see what they're saying, is that it doesn't give accurate readings. So we wanted to go see if we could accurately get readings from the ones that were at the storage facility. And Mr. Babcock says, no, you can't have been rendered incapable of doing that. It's a way to defend this. Are they accurate still? They've been oxidized, are they accurate? We can't do that, they're spoiled. That's the claim in the plaintiff's complaint. I've got to defend that. One of the ways I can do that is just as I explained. All right, Your Honor. Thank you very much for your time on this one.
All right. Okay. I can say this, and there's a couple issues. Number one, these are probes, and I get that. As far as it appears to me, if there was a consideration regarding the probes that were being utilized at the real water plant prior to sending, what was the number? 10, 12 probes?
Meters.
15
Meters?
15 meters.
15 meters. If this was really critical, there would have been a request for this to be included with the 15 meters and sent to the expert for testing. Right?
Okay, you think so?
No, I think so. If he thought it was really, really important, he would have wanted to test that specific meter. And it goes to really two issues. Number one, I'm still not convinced that, especially there's a conflict here as to the efficacy as to whether or not the meter in question still performs what it was designed to do. We don't know. And I don't know how you can make that determination, especially regarding meters, just based upon a photograph, unless the photograph reflected the fact that the meter was obliterated in some way, form, or fashion. It doesn't do that. I understand it's dried out, and I understand it has platinum tips, and there was some things in there how you can cure or whatever to the platinum tips. But my point is this: at the end of the day, regarding the warnings and whether they're adequate or not, that's what the case is all about. And it's my understanding, based upon the current status of the case, that the defense has an expert to opine on that issue as it pertains to adequacy of the warnings. And that's what the case is all about as far as the products liability aspect of it. And so anyway, I'm going to deny the motion. And I still go back to the timeline, because I think that's really important, because I keep coming back to this, if this was critical to inspect the actual meters, it seems to me that the request for inspection would not have been done after the initial expert disclosures and reports, and after the rebuttal expert disclosures and reports. I mean, because you would have hoped that would have been part of their initial evaluation process, and it wasn't.
We did it within 6 weeks, Your Honor.
Yeah, but my point is this: it wasn't done with the initial, wasn't done with the rebuttal, right? Am I wrong on that?
No, you're not, Your Honor. We did not ask that until then. You're right. Thank you, Your Honor. We want to take a break?
So wait a second, that would be 8 and the motion to strike.
They'd like to fold in number 8. That's fine.
Okay, good.
So that'll be denied as well. So our
Yes.
motion for spoliation and motion to eliminate number 8. Hannah's number 8.
Number 8.
You wanna-
So give me 15 minutes. I'll get you set up for what's the next one we're going to do, and I'll make sure that Mr. Kemp knows about what it is before we get
I'll
started.
give you whatever time you need, sir.
Okay.
Let me know when you're ready. I'm ready.
Thank you, Your Honor.
Right?
All right. Okay, next up will be.
Your Honor, we filed a motion with regard to joint and several liability with Real Water and the other defendants in this case. And let me just say that I understand joint and several liability maybe with Milwaukee, but I don't know how to be jointly and severally liable with Real Water with regard to the Real Water product. I don't know that we have a problem here. Mr. Kemp filed a joint opposition to Milwaukee's motion with regard to the same thing, joint and several liability. But I think we're in agreement that I'm not responsible because I didn't distribute, I didn't manufacture, I didn't design, I didn't sell the Real Water product.
All right.
Okay, so the question really is about judgment instead of jointly liable for that product. So I can't be jointly liable for the Real Water product. I believe Milwaukee and myself can be jointly liable with regard to the ORP meter and anything with regard to that. But part of this is stuff that we've already talked about in some of the other motions, that it's going to be hard for the jury, and that is why I'm still thinking about what should I really do here. There's one jury, but two different questions here, two different products. So,
Thank you. Okay. Sorry, Mr. Parker just was advising me he's either trying to or he just did sign in on Blue Jeans.
the motion for parts of summary judgment.
No, I understand. I just wanted to.
So I'd rather Mr. Kemp just tell me where he thinks I'm missing the analysis on my joint liability with regard to the Real Water product, because I don't think he's saying that, and I don't think the court should make me jointly liable for the Real Water product. And that was the basis of my motion.
Yeah, Judge, I talked to Mr. Rasmussen about this, and we are not contending that Mr. Odou is liable with Real Water, that just because Mr. Rasmussen sold an orb meter or he was in part of the chain of distribution, that renders him jointly liable with Mr. Odou. That is not our contention. We do think that if we show that his product is unreasonably dangerous, the orb meter, and that product was a substantial contributing factor to the injuries in the case, we do think if we do that, then he would be jointly and severally liable on any judgment that was entered. Not because he was in the chain of distribution, just because his product was a substantial contributing factor to the injury. So I don't know that it's really a summary judgment issue on joint liability. It's really a question, I think, of intervening superseding cause and foreseeable use. Okay, was it or foreseeable use of the orb meter that they were going to use it to make alkaline water? Is it so far out there that they got inconsistent orb meterings and added the product that would cut off liability? We don't think so. That's not really the argument the motion was made. But I would remind the court about that Price versus, I remember the case now, is the George Bush character mask. And so in that case, he was wearing this big
I
mask.
kind of do remember that.
Yeah, they're using a big mask.
Somebody punched him in the mask, right?
Yeah, and the mask tipped over too easily. That was the product defect of the case. Kind of like with these, Coke machines 30 years ago, they tipped over too easy. So the argument in that case was that the manufacturer of the mask could not be held liable because they couldn't foresee that someone would come up and push them from behind, which is technically an assault and battery. So the court, this is the Nevada Supreme Court, held that was not an intervening superseding clause. And what I mean by that's the act of pushing, because the manufacturer, that was a foreseeable misuse of the product. So in this case, I don't think there's an intervening superseding cause because, like I've already said, making alkaline water is a foreseeable use of the orb meter. And the consequence if the orb meter doesn't work right, that the water wouldn't be safe. They knew that too because that chart I showed yesterday about water quality, that's in their product literature. So they knew there was a relationship between the proper functioning of the orb meter and water quality. So I think technically that's the legal analysis. And I don't think a summary judgment is appropriate under that point. But I don't really think that's what Mr. Rasmussen was driving at in this motion. I think it was the first part, which is whether we were going to contend that he was jointly and severally liable just for selling his product if Mr. Odou was liable. And that's not our contention, Your Honor.
Right. So what we were trying to say, Your Honor, is let's go down the chain of distribution. But let's start at just Hanna, so that we're just dealing with the people that are in the case. Hanna sells an ORP meter to Milwaukee. Milwaukee sells it to Real Water. The ORP meter does not go from there to the consumer. It doesn't go from there to UNFI that then sells it to Whole Foods, or if I'm saying it wrong, Jim, I'm sorry, but then it goes to Whole Foods and then it gets to a consumer. But our product is the ORP meter. Their product is a Real Water product. Two different things completely. Just so that I've got it on the record, the water quality that was discussed in the product literature does not have to do with alkaline water at all. It doesn't have to do with water that's going to be drinking. It's water quality like in swimming pools. So we still will be putting on a defense that there was no foreseeability that they were making alkaline water with chemicals in it. That's never happened. We've never seen that happen before. We have no idea that that's what people were doing. We know they were doing that here. It doesn't mean that we couldn't surmise something was going on, but that's going to be on Milwaukee. It's not going to be on Hanna. We don't know what they're doing with it. Infinity Life Sciences is what we see. I'll be honest with you. We said that. They says, isn't that one of those kind of pools they have out in Las Vegas? Those affinity. No, I mean they have those, but that's a different spelling and stuff like this. So, I don't know what to do with that. And the other part of this, Your Honor, and I'll just say it, is that with Real Water's now change in their defense. Is that okay to say it that way, Joel? We're not sure how to deal with that either from our perspective of we shouldn't, just because they're not going to be misuse of the product, are they saying that they agree that they're liable for that? In other words, if the ORP meter is used by them but misused, since they're giving up on liability, is that defense also being tossed away? That's really a question for Mr. Odou to answer. And I don't know the answer to that question because they're not, I don't know. Joel, is that?
We're not really part of this motion, so I'm not sure that I can really weigh in on that. Our position with the plaintiffs is we're working on the stipulation now, and everybody will see it when it's filed.
So I don't know what to do because one of our defenses is going to be misuse of product, our product. And so how far does the stipulation go? We don't know. So Your Honor, maybe, I hate to say it, but this may be something we have to kind of
I think we're going to have to handle this vis-à-vis jury instructions in the verdict form, probably.
Yes, Your Honor. I agree. And the case I was referring to is the Price case. It's cited in our joint opposition on page 25. And that's where the court talks about intervening superseding cause and resulting consequences and all the things that have to be in the jury instructions.
That's it on that, Your Honor. I don't know what to do other than we'll wait on that one.
Yeah, I think, yeah, and you know, when I sit back and look at that, there's quite a few ways you could potentially defend this case, right? And so, but it seems to me that I think the best way to handle it, and I think your instincts are correct, sir, and maybe there will be a bone of contention as far as the extent of the instructions, but just as important too, there might not be. You might agree. It sounds like to me, in a general sense, you're kind of agreeing now, as far as the thrust and focus of what the instructions will be and what the issues are.
Yeah, the question is I don't know the full stipulation yet, so I can't comment completely, but we'll have to deal with this. I certainly don't want my motion to be denied until we have the
No,
stipulation.
this is what we'll do. As far as the motion is concerned, maybe it's premature at this point, number one. So I'm not going to deny it. Just as important, too, these types of issues regarding the full extent of the stipulation, the impact in this case, and how to handle potentially joint and several, I think we're going to have to handle that in such a way based upon a series of jury instructions.
Thank you, Your Honor.
And potentially a verdict form.
Agreed, Your Honor. I understand. Thank you very much.
Okay.
We're moving
But
now.
there's no waiver. We'll just put down this one's premature for now, and it will be resolved when it comes time to settle the jury instructions.
Your Honor, let me go to our motion limit number 9. Or could you put that up on the screen for me? Thank you. Going to be starting on page 6, please. Your Honor, this is our motion in limine in which we say, look, lay witnesses trying to tell us whether or not warp meter readings are inaccurate should not be done. They're not experts. And in the case of Casey Akins, he didn't even have training on what the heck was going on. He had been on the job for a week when they gave him an warp meter and said, go figure this out. Now, how to use it, put the probe into water, turn on the machine, that's all he knows. What he can't do is say, is this an inaccurate reading? He doesn't know. In fact, the testimony will show that going to page 5. I just on the court. 6, excuse me. 6. So, having...
Okay, mine seems to be screwed up here.
I don't think so.
Did I mess up?
No, you didn't mess up.
My staff did. Go ahead.
Okay. You need some time, Will?
No, I'm fine.
No, I was asking
Okay.
opposing counsel.
I'll ask the court if I need it.
So Casey Akins is a high school graduate, but not trained in open meters prior to his employment. We know something of his background. It has nothing to do with chemistry. It has nothing to do with water bottling. Okay? And they put him in charge of this warp meter. Okay? He took a measurement. He thinks it was around 130, negative 130, which is below the 225 that they want it to be at. That's real water's parameters, not ours. Okay. So the question that is there is that when it's negative 130, is that an inaccurate reading by someone who doesn't know if it's inaccurate or not? Okay. So we're going to have a guy come in there and say, well, it was below, therefore it had to be inaccurate. You're making an assumption there. Okay? So, but let's read what he says. With regard to his phone conversation, so he called,
Wait, I want to follow you. What page are you on?
I'm so sorry,
No, there's no reason. I just want to make sure I can follow you.
page 6,
Okay.
start with line 7, Your Honor. Casey Aiken took a measurement that was below negative 225. He called Blaine Jones, the vice president of Real Water, and asked him what to do. Hey, what do I do? I don't know what to do. I've taken the measurement. Mr. Aikens had probably been working as an operations manager for less than a month, and I think that's probably true. Mr. Jones decided, not Mr. Aikens, so there's a decision that's made, that the meter was correct in measuring the water sample. Why? Because he told him not to do what? We'll change out the meter and let's get a new one and see if that helps. Or take another reading. Or take out and put in a new probe. Or anything to do with the meter. Mr. Jones says nothing about the meter. He says, we know this because instead of changing out the meter for a new one, he told Mr. Aikens to add more chemical concentrate to the water tank. Okay? So there's your event. Okay? Now, what you know and what we know is that Aikens then makes the decision not to add just another cup of concentrate. He adds another full 2.5 gallons, he thinks, it may be 5, of concentrate into the tank. In other words, he doubles the amount. This is not something that we can see. It has nothing to do with us. This is now really about the real water product. So that's why this joint and several stuff comes into play here, because I can't be liable for what this guy's doing. But I also can't be liable for him saying, because he doesn't say it, yeah, this was an inaccurate reading. And this has to do with the bad batch that 5 of the plaintiffs in this case consumed. What did he testify to? This is his quote, starting on line 15, page 6. And so you measured it, and for some reason it measured 130 that day instead of, and then he cut me off and he says, it was lower than it should have been. Right. Question, and when you measured it, you used the ORP meter that we have here as Exhibit 1. Answer, yes. So you called up Blaine and told him you had a problem. Yes? Answer, yes. And so he told you to add more concentrate. So remember, the meter didn't say that. And we don't know that the meter is inaccurate because all they did was add more concentrate. In fact, you wouldn't do this unless you thought the meter was accurate. So someone's going to have to come in here and say, oh, it was inaccurate that day. And the only people that could do that is the guy that's doing the measuring, which is Casey Aikens. He's not qualified to do that. There's case law on that. We've cited it. I'll go over it. Correct. But he didn't tell you how much. No, he didn't tell me much. And that's really not at issue here as to how much to do that. That's their decision. What do I do with this? Okay? Getting down there, so we go down to line 15. So you add in another 2.5 gallons. Yeah. Then he says, remember, there's nothing on the ORP meter that says, warning, don't add any more concentrate. Warning, this could be bad. Because all it does is a measurement. It'll measure anything good, bad, or indifferent. It doesn't matter what you're measuring. Okay? It's not a safety device. It just measures. It's like a tape measure. It just measures things. The wood that you put in your house, and I've had these CD cases. Okay? Well, the 2 before that they used in the framing was good, but it hadn't been cured properly. So it leaked, or the particle board didn't have enough this in it, and so it allowed water to come through the roofing membrane. But the tape measure that they used to do it wasn't wrong. And there's nothing in this testimony that says, oh, it was wrong. So they're going to use a lay witness to say, no, I think it was wrong. I think based on this testimony, Mr. Aikens knew that this was an incorrect measurement. Well, no, obviously him and Blaine Jones didn't. Instead they did the exact opposite of confirming that this was good. They did something else. Is there any problem with the ORP meter at that time? Not that I knew of.
Here's my question, and it's really this simple. If experts were required to utilize the ORP meter, why weren't there instructions given that only experts...
Go to the box, please, in the warning label, the very first one.
When, what does it say?
Someone knowledgeable. Pull that up. This, the enclosed product is intended for use by persons knowledgeable
Okay,
in safe laboratory practice.
right.
In other words, if you don't have that knowledge, you shouldn't be using this machine. We've warned them.
Well, I mean, that can be part of your defense, but I'm coming back to, I mean, and from what I gather, just reviewing it, it was dealing with inconsistent potential ORP readings, right?
But they're claiming, but we have the one reading, right?
But what does that go to? That goes to, and I'm, correct me if I'm wrong or not, because I want to make sure I deal with the right term of art. Because we
I
have
appreciate
to
that, Your
be,
Honor.
yeah. But doesn't that go to the issue of conditioning?
Right. So Blaine Jones gives him a meter that had previously been conditioned. He uses it. Blaine Jones, who did the conditioning, okay, gets a phone call, and they say to Blaine, "What should I do?" Well, what does Blaine Jones already know? I've conditioned these ORP meters. Okay? They're being kept in distilled white vinegar. I'm following the instructions that are here. So his decision is what? Add more concentrate. The mistake was.
Oh, and it might be a big mistake, but my point is this, and I would, until, I just want to make sure I understand what's going on here, because I would anticipate, based upon maybe prior ORP readings or whatever, that based upon the mixture of the concentrate, they would anticipate it would come back within a certain range, and that didn't happen.
No.
And that's what, and that caused a big potential problem.
Mhm.
But if he's performing the same function over and over again, and it doesn't come back in the range that's anticipated based upon the concentrate, and they know what the range of the concentrate is.
That they want.
Yeah, that they want. What's wrong with him saying, "Look, I tested it and it just didn't come back in the range I anticipated"?
So the range has nothing to do with regard to the liability. What they're saying then is, well, then that 130 had to be inaccurate because it wasn't conditioned properly. But Blaine Jones conditioned these. We saw him do it on the videotape. He knew how to do this. He had the oxidation kit there. But what we're going to do is a bunch of lay witnesses now trying to say, I know if it's inaccurate or not. If it reads 130, that always has to be inaccurate. Well, what if the mix of the concentrate that was added was wrong? It can't always be the meter.
Well, no, I understand that, and why can't you say
And I will
that?
do that, but having people that are not experts opining on the witness stand, oh, it was inaccurate. I know it was. How do you know that? Well, I just do. Why? Because it didn't meet our range. That's not testimony. That's jumping to an expert opinion. And that's what this motion is about. We shouldn't have people that are not experts on analysis and ORP and how they operate because they are knowledgeable in safe laboratory practices up there opining about something that they know nothing about. This guy's been on the job for less than a month. How can he opine on something like this? He has a high school education, which is great. I applaud that, but I'm not saying he's qualified to do this. So when they bring in different people that are not experts and say, see, it's inconsistent. Well, how? How are they qualified to do that? We've given you the hallmark and Chapter 50, or NRS Chapter 50 on experts. Now we have a bunch of non-experts are going to tell you, because that's the only people they have, these were all getting consistent ratings. We know it even though they had every opportunity to oxidize this, every opportunity to investigate it, to use a different meter, all of those things. Nope. Our non-experts are better. The case that I want you to think about on this one is on page 9 at line 27, starting on line 27. It's the Vargas case, Southwest
Gas versus Vargas. It's a 1995 case. Witness testimony lacking any evidentiary basis and support is irrelevant, confusing, unduly prejudicial, and must be excluded. It cites the Mikulik case versus Carrier. Nevada Supreme Court stated in Mikulik, the general rule that a witness must testify to the evidentiary facts and not his conclusions, opinions, or inferences has been so long and so well recognized by this and all the other courts in this country as not to require discussion. So lay witnesses should not give expert opinions. And the expert opinion that we're trying to make sure is excluded is, we believe that these orb meters were reading inaccurately. How does anything in the Casey Aikens deposition testimony that I just said to you suggest that he would be qualified, number one, and that he thought it was inaccurate, number two, and that we can somehow make him into something that he isn't? That's just one of them. Okay? And so we have a group of them. They have a Diego Indigana. They're going to try to say, oh yeah, he knows that they're inaccurate. Well, how does he know that? Well, when they wear out. Well, that's wearing out. That has nothing to do with accurate at the time. And then they put on a new meter or probe, and where they go. We are into an area where I think the court should grant our motion that lay witnesses do not give expert testimony. And it's long been recognized, as we just discussed in this, why that sort of thing happens should not be allowed by this court. And that's my motion, eliminate.
Here's my question, though. If that was so important, why were these sold on the open market? And they should have been maybe limited to laboratory settings and things like that.
That's why we put this on there, and that's why they get sent to who wants to buy them. What do you mean open market? We literally say on the warning.
No, but I'm talking about, for example, there's certain types of devices and things that are typically sold to consumers or sold to labs and all sorts of things. But because here's the thing, what do I do about this one? This is the one issue. These are what they were doing. They were performing whatever function, whether they should have been performing this function or not, that's another issue. But these are what their findings are. Now, I understand one of the issues might be, well, whether the probe was properly oxidized, right? I mean, I kind of get that. But you're telling me that because they were not experts, and I don't know what type of expert, I guess they'd have to be a chemist.
Maybe an engineer of some sort.
Okay, so they'd have to be an engineer or a chemist, notwithstanding the fact that they were using this product for years to prepare oxidized water to sell on the open market. So you're saying that what findings they found, and I'm not saying they're rising to the level of saying, look, the product was defective. They were getting inconsistent readings, and based upon the inconsistent readings, they did certain things they probably shouldn't have done. But that's another story. That's up for the jury to decide. That's the bad batch or whatever. But you're saying that they can't talk about what they were using the meters for?
No, they can't. It's the next step of analysis that we'd like to prevent. Let me say, Mister, did you do this measurement? Yeah, they can testify to that.
Okay.
What was the analysis of that measurement? What do you believe that measurement was supposed to be and why? I don't know. I'm not an expert. What's the analysis? What does negative 130 tell you as opposed to negative 225? I don't know. I'm not an expert. How much? Why did they choose negative 225? I don't know. I'm not an expert.
But
How do you know it was accurate? I don't know. I'm not an expert.
so you're saying they can't talk about the orb?
They can say, yes, it read negative 130. But how do we know that reading was inaccurate? What evidence do we have? Here's what the evidence they could have had. When the negative 130 came up, it was still jumping around. The numbers were moving on the machine. Things weren't right. It just didn't feel right. It seemed funny. Whatever they want to say. But that's not what happened with Casey Aikens. What did he do? He called Blaine Jones, the vice president, of Real Water, and said, here's what I've got. Okay?
the reading came in, it stabilized at negative 130. It's not negative 225. What do I do? Blaine Jones, okay, who's been, you saw the video, oxidized these machines, says add more concentrate. He doesn't think it's inaccurate. And what I'm trying to say is we shouldn't allow Mr. Akins or Mr. Jones to come in here. Neither of them are qualified to say, oh yeah, it's inaccurate. How? How do you know that? What evidence do you have? How do you know that Mr. If Jones comes in and says, I can tell you what Akins was doing, really, you weren't there. Called you on the phone. How do you know he put it all the way in the water? How do you know he didn't use it the wrong way? You don't even know that, but at that point, you thought he did it right, and if you thought he did it right, what you told him to do was accept that number as true and add more concentrate. And the Vargas case tells us witness testimony lacking any evidentiary basis and support is irrelevant, confusing, and unduly prejudicial and must be excluded. That cites the Mikula case, the general rule that a witness must testify as to the evidentiary facts and not his conclusions. Hey, did you think it was inaccurate? Opinions or inferences has long been so long and so well recognized by this and all other courts in this country as not to require discussion. I don't want lay witnesses getting up here and saying their conclusion, oh, it was inaccurate. It wasn't oxidized properly. How do you know? How do you know? Because Casey, we asked Casey, did you ever oxidize one of these? Nope. Who did that? That would be Blaine Jones. So he can't testify about that. So how does he know if it's inaccurate or not? You'd have to be an expert in something. You'd have to either have first-hand knowledge or something. But if you're going to use this machine, you should know what? Knowledgeable. Knowledgeable in safe laboratory practices. Now, this gets to that joint and several in some ways, but think it through with me with regard to real water. If I'm going to put out to the public bottled water, all I get's an ORC meter, which tells me the electrical voltage of water, but I'm going to sell this to the public. Don't you think I would have a laboratory there to do water samples? Having said that, I'm not going to go that far because Joel should come out and mess with me, is that they did have an independent laboratory that tested all of this, looked at the chemicals that were in the water. They didn't do a hydrazine test, but they checked on all of this, okay? All they're trying to do, by that chart the other day that said negative 25 and we want negative 225. All they want to do is sell alkaline water. It just has to read negative. It's not a safety device. It's just a measuring thing. It's just like a tape measure. It doesn't do more than that. I don't want these witnesses coming in and saying something different. That's all I have in number 9. Thank you, Your Honor.
Okay, thank you, sir.
Your Honor,
Sir.
Joel Odou for real water. I wouldn't take a position on this motion, but I would take a position on trying to restrict what Casey Aiken or any other independent witness is going to say. Your Honor, we don't control Mr. Aiken, and we think if Hanna or Milwaukee wants to raise an objection to the question asked, that's fine, but I don't want to run afoul of this motion if it's granted that somehow we're responsible to instruct this witness as to what he's going to testify. The facts are the facts, and whatever.
Well, that's why I keep
he's
coming
gonna
back
say.
to the facts are the facts, right?
Exactly, Your Honor.
Okay.
And as far as the use of a tape measure, whether you've got to be a scientist to do that, I'll save that argument for the jury.
I understand. I do.
There's actually 2 motions here that are on the same issues, 9 and 10. And we filed a joint opposition to them. Yeah, it's Hanna MIL number 8 to preclude questions of experts. Excuse me. It's 9 and 10. Hanna motion number 10 to exclude testimony regarding ORP conditioning affecting accuracy. And Hanna motion number 9 to strike any evidence of ORP meter read inaccurately. Mine must be wrong. Inaccurately by operations that are not qualified to determine accuracy of the meter readings. So we filed a joint opposition, and the first thing we pointed out that in neither motion did they identify one single piece of evidence that they wanted to exclude, They did
No,
not.
I looked at that because it appeared to me that the issue's inconsistency of the
Right, so-
readings.
So they didn't identify any evidence. They didn't identify any witness. You know, we heard this big thing about Casey Aikens. His name wasn't in either one of these motions. They just filed a generic type of motion. So what we did in the opposition is we went through every possible piece of evidence that we could think of that was relevant to this area, and we pointed out why we thought it was admissible. You know, first of all, there was product literature that says that it can give inconsistent readings if it's not conditioned appropriately. So we pointed out that. Then we had Jason Brown's testimony. Again, he's the general manager of Milwaukee, who said that if you don't condition it right, it will take hours or days to take negative warp readings. I understand they think his testimony is mistaken, but that's what he testified to, Your Honor. He had the depot for 30 days. He didn't change that. Okay. The next thing we pointed out is there were emails back and forth between Milwaukee and Real Water, and maybe I can have a couple of those. Remember, Milwaukee was a big customer. They ordered 90 of these warp meters over a 6 or 8 year period. So here we have Jeff Desitel. He's at Real Water. He's, again, the former Marine or intermediate Marine or Army. But so he writes a direct email to Milwaukee talking about the conditioning kit, wanting to order them. Says I've tried to order it online with no avail. And look at the date of this email. It's December 2016. So they tell him
17.
17. I'm sorry. 17. So they tell him, this is Brian Moore. This is the person that died, and then Jason Brown took his spot. So on December 7th, like Pearl Harbor Day, he tells him the kit is no longer available. Can't use it anymore because it's toxic. All right. But my point here is that they knew who bought this meter. They were having direct email correspondence with them. Let's go back to the top. Mr. Test, drinkrealwater.com. Okay? I mean, I think that gives you a little bit of a clue here that they're using this in connection with the water product. But needless to say, they were not limiting this to scientists. You know, there are products that are sold that the manufacturer adopts procedures to make sure it only goes to a certain target audience. They didn't do that. You could buy these on the internet. I mean, I bought them. They're even selling them to lawyers, Your Honor. So to suggest that, we can put something on the label saying only for use in safe labs or whatever it's on the label. I mean, they knew Real Water was buying these. Again, they sent them 90 of them. So I think it's foreseeable that it was being used by non-scientists, especially when they were promoting the product to be used to make Kangen water. They have product literature that says that this product should be used to make Kangen water, alkaline water for drinking. I don't think there's any credible argument that they thought a bunch of scientists were out there making Kangen water for themselves. You know, they knew this was a widely used product, and that's how they promoted it. So to suggest that, there should be some kind of limitation to scientists only as a matter of law. But now let's get to the witness testimony that they want to preclude. And I look at this as being governed by 50.265, what lay witnesses can testify to, and maybe Stackowitz. Okay, let's start with 50.265. This is a meter that has an LED readout on it that you're supposed to read to determine what level the orb's at. That's the whole purpose of the device, that a person can look at the LED and try to read it. Now, to suggest that somehow or another the express purpose of the device, reading a number on an LED, is beyond the scope of lay witness testimony, Your Honor, let's look at some of the testimony. You got Mr. Mendangas from the opposition, please, Chris? Probably. Yeah, here we go. Oh, no, keep going. That's the product literature I just talked about, Your Honor. So this is Mr. Mendigana. He worked on the retail line. So he testifies that he had inconsistent or funny results 18 to 20 times. Okay? And it was explored in the deposition what that meant, and he gave his understanding what inconsistent meant. But this is credible witness testimony that should be excluded. Now we get to Mr. Akins. So Mr. Akins starts out saying that the reading's lower, and again, none of this testimony was identified in the motion as being the target of the motion. We put this in the opposition because we were concerned that a broadly filed motion could potentially impact this kind of testimony. So he testifies, reading came back lower, what should I do? Add more concentrate, keep going please. And then he says what the reading was, like negative 130. That is the reading that this witness saw on the org meter. So to suggest that Mr. Aiken can't testify to what he saw with his own eyes, that's clearly within lay witness standard. Next, please. Okay, stop. This is the Stackowitz case, Your Honor, which you're familiar with. In Stackowitz, the court held that the lay witness, the driver of the Nissan vehicle, could provide testimony that there was a steering defect. And that testimony alone was sufficient to get to the jury. Didn't need an expert, okay? And now, after Stackowitz, we had another case from the Nevada Supreme Court. That's this Squirrel Company's case. And that court held that it's too burdensome to require a plaintiff to prove precisely why a product doesn't work. And specifically in instances where you have electronic and mechanical components, that's exactly what we have in this case, Your Honor. So to suggest that we have to have had some sort of electronic device that had some kind of self-memory, like some of the cars do now, and that that's the only way you can prove a product case, or alternatively, that every square inch of the plant had to be videotaped at all times, and we have to produce the videotape. Those are the only other two ways you could have proved something like this, other than the lay witness testimony about a matter that is within their comprehension. So can we go back to the next page? And then we had another witness, Your Honor. This is Patty Converse's testimony. Again, she was the quality control director that was promoted for being a receptionist. So she testifies that they had problems in the calibration of orc meters, and I think she meant oxidation. I don't want Mr. Rasmussen to get upset here. But so she testified to that, and the solution was to order more meters. And like I already said, they ordered 90 meters, which is a pretty large number, which in and of itself suggests there was some sort of problem. So this is the testimony that they're here. Let's go up a little bit more, Chris. These are the invoices, 90 meters over 9 years. So they're buying 10 a year. Remember, these are supposed to last 1 to 2 years. So they're buying 10 meters a year, or a meter that lasts 1 to 2 years. I mean, the meters don't cost that much. You know, they're pretty cheap, $90 to $100. But still, they're buying lots of meters. So for those reasons, Your Honor, the fact that we think it's within the ken of the lay witness testimony, and also Stackowitz, and also the fact that they didn't identify any testimony at the outset in the motion. You know, they were painted with such a broad brush. I think both motions should be denied. Thank you, Your Honor.
Well, I'll be very quick, Your Honor. I actually read it with you. Mr. Kemp may have been doing something else at the time, but I literally read you the Casey Aiken's deposition transcript. I hope you recall that I actually went through it line by line with you right out of my motion. The very stuff that he then shows you again. It's it's now being shown to you again on page 6. I literally read this to you. I don't know any, Mr. Kemp is saying I didn't, or it wasn't in my motion. The exact language and the exact testimony. I'm trying to say, you can't pivot from, yes, Mr. Aiken can say, I got a reading of negative 130. Yes, I put the probe into the water. Yes, I was working there that day. Yes, I had an ARP meter in my hand. That's all facts. It's the next move. What did negative 130 mean to you? His response was, didn't mean anything to me because I called Blaine Jones. And Blaine Jones told me to add more concentrate. So the decision, the analysis of this, in other words, is it accurate or not, was never on the table. And I don't want a lay witness like Mr. Akins to say, did you ever consider if it was inaccurate or not? No, that consideration was done by Blaine Jones. Okay, and what did he say? Add more concentrate. He did not say, I wonder if these meters have been accurate lately. No one's making that analysis. Someone that can do that is a expert. Hey, someone who knows if it's inaccurate or not, because they're knowledgeable about that instrument. That's the reason I just showed you the warning label. But I gave you all of it on page 6
and
7. Yeah, I read it. It's in my motion. I don't know why maybe he was doing something else, but I literally went through it line by line. There is nothing in here that talks about inaccurate readings. This is the super bad batch. This is what happened. And I don't want someone to come in and saying, well, as an expert, Casey Akins thinks it's inaccurate. Well, where does he say that? Where does Mr. Jones say that? There's nothing there. So to suggest that that's what it is wrong. And if you want to do that, you better have somebody that's qualified to be able to say it's inaccurate. And there's nothing in this testimony that says so. And that's why I cited the Vargas case that says exactly what it does. You can't do this. And Mikulik that says, this is already decided. This is well-decided law. You can't have a witness get up there and start talking about things like this when they don't have the experience to do so. The general rule that a witness must testify to the evidentiary facts and not his conclusions. First thing is, what do you think about this? I didn't conclude that. All I concluded when I got that was I needed to call Blaine Jones. That was his conclusion. That's a fact. He did call him. That's it. It can't be used to suggest we think there's inconsistent readings. With this particular one, there is no inconsistent reading. Why was it negative 130? Well, there's scientific reasons for it. It's pretty simple. We'll wait for trial, I guess, to talk about it, unless you want to hear from it right now. It's pretty simple. But he's not an expert.
I mean, does he even at one point talk about the meter somehow not functioning correctly?
No.
So, I mean, okay.
So what I'm worried about is that we're going to get somebody in here that's going to say, please give us your conclusions. Give us your expert opinion on this. This whole thing is, and for lack of a better, let's keep people that don't know what they're talking about with regard to how you decide what the meter's reading means out of here, and whether or not it was inconsistent or not, because there's nothing about inconsistency in his discussion. He's only been an employee for a few weeks, Your Honor.
Yeah, but I mean, I see. I mean, are they alleging that it was defective because of the readings?
What they're alleging, and I'm sorry, I got too passionate there. I apologize.
No, that's okay.
What they're alleging is that Casey Akins, okay, when he did this, that this was an inaccurate reading. There's no evidence of inaccurate in any of the testimony that we've just read through.
Did he say inconsistent?
Never use that word.
Did he say inaccurate?
No. So you're making a jump to something that doesn't even exist.
But I mean, he didn't testify to inaccurate, did he?
No, Your Honor, he did not. And so I'm trying to preclude any sort of a discussion that Casey Akins and Blaine Jones, when they had a discussion about this, got to some conclusion together. Oh, yeah, the meter must have been inaccurate. They never got there. You know,
If you look at the testimony 17, it was lower than it should have been, right? Should have been 225.
and why was that?
because that's the standard that they asked for. We know why, but he doesn't know why, and he can't testify to that. How would he know as a lay witness why it says 130? He can say it's 130, negative 130, but he can't say, well, the reason is because it was an inaccurate meter. Really? How did you jump to that? You never testified that way. You've never said it was inaccurate. Remember, his testimony goes on later and he says, did you ever have any problems with the ORP meters? No, not that I recall. That's his testimony. I've already read that today. Mr. Akins.
What's the difference between inaccurate and inconsistent readings?
I don't know. That's the plaintiff's use of words. But we only have one reading here. And then, and by the way, after this, what does Casey Akins do? Every tankful after that, he doesn't add 2.5 gallons of concentrate. He adds 2. And he never says again that it was below 225. But there's nothing about inconsistent by Mr. Akins.
What about the literature as it pertains to potential inconsistent readings?
There's no literature that Mr. Akins saw. There's no literature that Mr. Blaine Jones ever cites that he saw. That has to do with Kangen water, if I understand what Mr. Kemp was suggesting. That's a different product altogether. There's nothing here that these guys say, I knew this. But let's focus just on the witness. Can this witness get up there and say it's inconsistent? He's never said, we asked him, did you have any problems with this? No.
Well, there's a difference between having any prior problems
Okay.
and coming up with inconsistent readings, because, I mean, the way I'm reading this
Okay.
is he had certain expectations as far as readings were concerned based upon, I guess, the composition of the concentrate, and he would expect it to be the same.
And it wasn't.
And it wasn't. So
Right.
Right.
And so what did he do? He called Blaine Jones, right? That's in the testimony.
But yeah, were inconsistent in that I was expecting a 225 or whatever the figure might be. But
Right.
he calls Blaine Jones,
Right?
and then he says adds more.
That's right. That's right. He wasn't saying that it was inconsistent. He's saying, I don't think there's enough concentrate. We need to add more concentrate. That's what Blaine Jones' decision was.
I understand, and that can come in, but I'm really trying to figure out where we're going with this.
My whole point, the whole thing on this thing is, certainly a witness can talk about their facts, they can't reach their conclusions. This conclusion is, my expectation was this. Was it learned that? Yeah, it was. There's reasons for that. It's so simple why it would do this. We've already had these factors. We've already talked about this. But to suggest that lay witnesses now can say, my conclusion was that the meter was off. No. In fact,
Well, but see, the meter can be, and maybe I'm missing this, the meter can be off potentially because, I don't want to say the wrong word, conditioning?
Got it.
Right. You know, I don't.
yeah, we'll get to the next.
Right. I mean,
Yeah.
but that doesn't mean the meter is, I won't go there either because I don't want to open up doors. But, and it appeared to me that potentially there was a conditioning issue. I don't know, but I'm trying to figure out,
Some way to help?
No, not some way to help. Some way to, he can testify as to what he can find. I don't think he's testifying or saying that there was there was something potentially wrong from a design and or manufacturing perspective.
Or that he was.
But what it comes down to, it's there might have been conditioning issues. I don't know, but his expectations were a certain level. He didn't get there, and so he wanted to know what to do. So he's not saying the meter was broke, is he?
Your Honor, that he didn't know anything about conditioning because conditioning was only done by Blaine Jones.
I understand that, but that's why
So
he would
he'll
call
never
it.
have that in his thought that it could be a conditioning issue.
Right.
Can't have that in his head. Can't have anything that he doesn't even know about. All
Does
I'm
he
saying-
say anywhere that the term of art you were talking about, I just want to make sure I'm clear, that
We have a. Go ahead. Conditioning versus calibration.
no.
Oh, I'm sorry.
I don't want to open up any doors
Okay.
because that can lead to
Our next motion is going to deal, our next motion, the last one we'll hear is on that very subject.
On the condition?
Yeah.
Okay,
How are we doing these votes?
let's go to the conditioning part of it too, if we're doing both. But I'm just trying to figure out, I understand, what is the question again? Because the motion in limine is this, it's, unless I'm missing something, to strike any evidence that the ORT meter read inaccurately by operators that are not qualified to determine accuracy of it. I don't think that's what he was doing. He was dealing with the readings.
I agree with you, Your Honor. If he says negative 130, I can't get away from that. You're right. His conclusion, though, my expectation was this, therefore it must have been inaccurate. That's not evidence here. Can't be evidence here.
Does he say that?
He doesn't. He says, I called Blaine Jones to give me what should we do about this. He doesn't reach that conclusion at all. What's your conclusion? All right, so my SOP, I'm going to call Blaine Jones. He never says, I think it's an oxidation. I think there's an oxidation issue. I think there's something wrong with the meter. How do we know that? Because he never even looked at that. So I don't want this evidence to be, see, right here, he's worried about it. He can't be an expert on this. He can't reach his conclusions about oxidation. He's never done it. He has no experience with it. So he calls somebody with experience, and what does the guy with experience say? I've oxidized these. Doesn't say that. Okay? But we know he oxidizes them because we saw him on video doing it. Right? And he says, no. I want to do this instead. What I want you to do instead is add more concentrate. Now, whether or not he added the right concentrate, too much concentrate, that's not on me. That's training of Mr. Aiken, right? I have nothing to do with the concentrate. We're just kind of into the joint several liability.
Here's my last question on this issue.
Okay.
Are they alleging that the ORT meter, I probably shouldn't have opened up another can of worms.
Okay. I'm sorry, I'm not trying to do that to you.
Because you have the conditioning component. This is evidence that the ORT meter read inaccurately by operator that are not qualified to determine accuracy of meters. I don't think they were offered for that. They're just offered to make a determination as to what it read.
Yeah. If all he says is negative 130 and that's where his testimony ends, you're right. But if he goes past that, my conclusion from that was this. Because his conclusion from that was one way. Call Blaine Jones.
Okay.
Yeah, but what I think is going to happen is, no, Casey Aikens thought there was an oxidation problem. And there's been so many inconsistencies with them, that's had to be the
But if
problem.
he thought it was an oxidation problem, why can't he testify to that?
Because he has never even oxidized one. He doesn't even have that background to do so. He can't. I mean,
Your Honor, he was trained by Mr. Jones after this incident as to how to oxidize the meter, suggesting that they thought that there was a potential oxidation problem. And that is circumstantial evidence that there was an oxidation.
after the fact. After the fact. At this time, he has no thought in his head even about oxidation. He has no idea what it is. He has no idea what's going to happen. How can you testify about something you don't even know? And that should be evidence. That's the whole point of the Vargas case. You can't just put out this stuff and do this. Is this an important motion? Yes, it is, but it's pretty simple too. Should we allow? Okay.
But
I'm
here's
sorry.
no. Here's my next question. If he didn't think there was some issue, and I said that on purpose, with the
I heard
meter,
you.
why did he call?
Let's do that. Let's go through it very quickly. There is a parameter that's been set by real water. We want the reading to be between negative 225 and 300.
No, I understand that.
Okay, that's it. That's all there is. If the number is below that, 130 is, okay, something's got to be done, okay? He doesn't make that decision, right? He doesn't make that decision. He calls Blaine Jones and says, Blaine, make the decision for me. That's pretty simple. Hey, boss, this negative 130 came up. Tell me what to do. Hey, boss, tell me what to do. That's literally what he's saying. This isn't, it was inconsistent. I knew it was inconsistent. This was wrong. It was, none of that's there. Can't be, because he doesn't testify to that. In fact, he testifies, did you ever have any problems with it? Nope, never did.
Was he asked the question by you during the deposition regarding whether he thought it was inaccurate or not?
Yes, Your Honor.
What did he say?
No.
And we're talking about the technician that was performing the function.
Yes, Your Honor. Casey Aiken was the one that was doing the reading with the ORP meter, yes. At the facility, the Henderson facility, in September and October of 2020.
Okay, last but not least, what is the true issue here then? I mean, he can,
What-
of course, factually testify as to what he was doing, what his findings were, what he did once he found out that the meter wasn't performing as he anticipated vis-a-vis the results.
Okay, I guess putting it another way, the reading was less than what he was told it should be for what they wanted. Is that a fair statement? They wanted negative 225, not what we wanted, and it was at negative 130. So what did he do? He doesn't conclude anything about oxidation because he can't. He doesn't know anything about oxidation. I don't want to keep going around and around this, but he doesn't. So what I'm worried about is that someone's going to say, no. He can absolutely say what he concluded from that. Well, his conclusion is pretty straightforward, isn't it? I got to call the boss. What do I do here? And I don't want to make him into an expert that his conclusions that are not there all of a sudden become evidence. Casey Aikens can't be someone that makes a conclusion on this, and that motion should be granted to say, as to Casey Aikens, he cannot conclude, give an expert opinion, do something under Chapter 50, okay, in violation of the Vargas case, that now he's got a conclusion about oxidation when he's never done it. And that this was an inconsistent reading. When he's been there for a week doing this, how does he even know if it's inconsistent? Because he doesn't do that. He calls the boss. Tell me what to do. Add more concentrate. Don't change the meter. Meter's fine. Thank you, Your Honor.
Mr. Kemp, what about that issue? I just want to make sure I understand, because I'm
The
trying to
motion
understand.
says that they want to strike people that aren't qualified to determine the accuracy of the meter readings. That's what the motion is.
Yeah.
That's what we responded to. Now it's morphed into some sort of anticipatory testimony from Mr. Aikens that he's going to come in and say the meter wasn't properly conditioned. Okay? You know, I don't know where counsel gets that, but I think Mr. Odou's right. You know, this is the kind of thing you handle at time of trial. And if you think you're going in an area that the witness can't, a lay witness can't testify to, you make an objection, we handle it at trial. So the motion as drafted and as we opposed it should be denied. Okay? These theoretical, what if he says this, what if he says that? I think, how do I know what he's going to say? All I know is what he said at the time of the deposition, which was that he thought that, quote, it was lower than it should have been, right? That was his answer, because he was given a piece of paper with the parameters of 225, and he got 130, so he says it was lower than it should have been. He calls Blaine. Blaine tells him to put more concentrate in. He does. We have all the outbreak cases. They're getting all these calls, and after that point in time, Blaine Jones and Mr. Aiken have a training session on how to condition the meter. Okay? I think that's pretty good circumstantial evidence that both of them thought that there was a problem with his training. But these are just facts, Your Honor.
Yeah,
These
but
are not-
I get that. I'm just trying to understand, because he doesn't say that as far as his testimony is concerned, and he's going to testify to facts that he has.
Right. So he can testify that he didn't condition the meter, and he didn't. he didn't condition the probe on the meter.
Probe, I understand.
And then Mr. Rasmussen keeps saying that Mr. Jones conditioned the probe on this meter, and then he flips back to this 2014 video 6 years earlier. There is no evidence that Mr. Jones was involved in conditioning meters at this point in time, referring to 2020, 2019. In fact, exactly to the contrary. He testified that he had started removing himself from the operations, and so he wasn't the one that would.
I apologize, Your Honor.
Yeah.
That's okay. That's fine.
So
Is that baseball? Is that baseball?
I don't know what factual basis.
That's
Mr.
okay. I'm a baseball fan. So.
I don't know what factual basis
It was
Mr.
a
Rasmussen
mistake.
has for the proposition that this specific meter was conditioned by anyone, much less Mr. Jones, or that Mr. Jones was regularly conditioning meters at this time, because he wasn't. Okay, so all we know is that after they started getting the complaints, that Jones took Aikens and had a training session on how to condition the meters. That's what we know. Those are facts. But again, this motion is not qualified to determine the accuracy of the meter readings. That's all it says, okay? And like I've already said.
Well, the thing about that is, and I mean, he just reads the meter.
He just reads the meter. and
He
gives
just
the
reads the
results.
meter
Right.
and the
Right.
results.
So what he can't do as a technician is tell you whether or not it was accurate. He just reads it. And that's all my motion says. Whether or not it was accurate is not his question. His question is, can you read this number? Yep. Can he tell you if it's accurate? Nope.
I like hearing from Mr. Odou. I do.
Your Honor, we don't control Mr. Aiken. He's going to answer whatever question is asked.
Right.
And to
I
try
like
and
Mr.
pre-instruct him as to what he can say is a disaster.
Yeah,
He's
yeah,
a
well,
simple man.
and Mr. Odou always has wisdom. He really does.
Well, I'm afraid of what he might say if we try to instruct him.
Yeah,
Well, you
I
told
mean-
me that I can't say that.
Right, right,
Then what do
right.
we do?
Yeah.
He may come.
That's all I have.
Yeah, I understand.
Okay.
I,
So if he does not come to trial, what do we do then? Just use this?
We do the page line like we always do.
Oh, and if we do that, then there's nothing about, then this should be granted.
well, if there's
Why is
nothing
it
in the
granted? There's nothing
deposition.
in there to grant it to.
Okay, thank you. All right, you're
Yeah,
on.
what I'm going to do, and it's one of those, I'm still trying to understand the thrust of it. His testimony is his testimony. Whether he was trained or in conditioning or not, that's another issue. At the end of the day, I can see potentially how this might be impacted by warnings. I get it. I'm going to be very cautious on this one because I've learned lessons from my other comments that I've made from the bench, and I don't want to say the right thing. The bottom line is this, and we don't know what he's going to testify to. Is he even under subpoena? You know, or
He lives in California. Right?
He
Okay.
is, Your Honor, but not a legally effective one.
I understand. I do. You know, and what I'll do is this: I'll deny it without prejudice, and we'll listen to what he has to say. If he goes too far and appears to be giving an opinion on the efficacy of these types of meters in general, that's a problem, right? And here's the thing. I see it this way. I mean, I understand there's issues regarding potential conditioning and those things. The facts are the facts as far as what happened there. But look at it from this perspective, sir. If it goes too far, make the objection. Just as important, he might not show up, and we're reading depositions, and it was never even addressed in the deposition at all, right?
Thank you, Your Honor.
Okay, I understand.
I understand the court's ruling.
Yes.
Moving to motion limiting number 10.